Welcome to the deep dive. Today, we're really digging into day 5 of the Karen Read second trial.
Yeah, day 5 was pretty intense.
Definitely. We're going to skip past some of the usual courtroom stuff and really focus on, the technical testimony. And there were a couple of moments that were genuinely unexpected.
For sure. And just so everyone knows, we're working from direct reporting from folks who are actually in the courtroom.
Right. So our mission today basically is to unpack what the forensic experts and these ARCCA experts were actually saying. Some of it gets pretty complex.
It does. We want to clarify the key points, figure out what really matters, and I suppose show why this particular day might be pretty significant for how you understand the evidence.
Okay, so what's interesting, I think, is how the day sort of split in two. It started super technical, all this digital evidence.
Phone data, search histories.
And then it just pivoted. Suddenly, it was all about the experts themselves, their credibility, even some procedural arguments bubbling up.
Yeah, so you can think of it as two main threads, maybe. First, there's the deep dive into the phone data analysis.
And second, this whole situation with the ARCCA experts, which got, let's say, dramatic.
That's one word for it.
Okay, let's tackle that first storyline. Ian Whiffen, the forensic expert, his testimony kicked off with that Google search.
Ah, yes, the how long to die in the cold search.
Yeah.
Been talked about a lot.
Exactly. And the initial focus, based on that Celebrate report from Jen McCabe's phone, was that 2:27 a.m. timestamp.
Right. And Celebrate, just quickly, is a standard tool they use to extract data from phones. Pretty common in these cases.
So Whiffen gets up there, and initially he says his role was, quote, to prove the truth. But then he immediately corrected himself.
Yeah, he changed it to explain when the search happened.
And that little change, prove versus explain, that feels significant, doesn't it? It's about objectivity for an expert witness.
Absolutely. It's a subtle but crucial distinction. Prove sounds like you've already decided. Explain is more like, here's what the data shows. His correction suggests he's aware of that need for objectivity.
Which probably helps his credibility, you'd think.
Potentially, yes. And his actual analysis directly contradicted that initial time.
Right. His PowerPoint, based on his analysis, concluded the search was actually at 6:24 a.m., much later.
So what of the 2:27 a.m. time then?
According to Whiffen, that was just the time when the browser tab showing those search results became the, active tab on the screen, not when the search itself was typed in.
Ah, okay. So a technical artifact, basically, not the actual search time.
Exactly. And he apparently got Celebrate to update their own report based on his findings. That's a pretty big correction.
It is. It changes the timeline significantly for that specific piece of data.
Then there's the fact the search was deleted. Whiffen testified he couldn't figure out how or why it was deleted, couldn't recreate it.
Which leaves a gap, obviously.
But crucially, he stated very clearly that Jen McCabe was not the one who deleted it.
Okay, that is important.
Yeah.
Because there was speculation.
Right. So if not her, then who? And why? That question just hangs there now.
Definitely a loose end. Okay, so after the search, he moved on to John O'Keefe's phone data, right?
Yeah, and this is where it got even more technical. Apple Health data, location tracking, even the phone's battery temperature.
A lot of data points. What stood out?
Well, remember the whole climbing stairs data. The prosecution's angle is that this shows John went up and down 3 sets of stairs, presumably inside the house.
Okay, but the defense had a different take.
Yeah, they argued it just reflected the car moving, maybe driving onto the uneven lawn or driveway at 34 Fairview.
Yeah.
And Whiffen actually did field tests.
Oh, what kind of tests?
He drove around on hilly roads, and his own phone registered similar climbing stairs readings just from the car's movement.
Huh. So the same data signature could come from just driving on uneven ground.
Apparently so. It shows how you interpret the raw data is everything, right? His tests offer a totally different, plausible explanation.
It really does. It suggests maybe that stair data isn't proof of him being inside at all.
And here's maybe the biggest point on this. Whiffen's own location tracking map. It showed John's phone approaching Fairview, Karen Read doing her 3-point turn. But at the exact moment the phone recorded that stair data, the GPS location put the phone still inside the vehicle.
Wow. Okay, so not inside the house climbing stairs.
Exactly. If the location says in the car when the stair data hits, it really undermines the idea he was inside walking around then.
That seems pretty critical. It supports the defense theory that the motion data is related to the car's arrival or maneuvering.
And there was more. The phone's temperature, it steadily dropped over time.
Implying what?
Whiffen suggested it meant the phone stayed outside, exposed to the cold. probably near the flagpole area where they arrived around, 12:24 a.m.?
Which is also where John's body was found later.
Right, so that temperature data seems consistent with the phone being left outside near the scene.
Another piece aligning with the outside scenario. Okay, so Whiffen finishes his direct examination, then cross.
Then Bob Alessi started the cross-examination. It got cut short, but he landed a pretty interesting punch.
What was that?
He pointed out that Whiffen's own data showed that when they arrived, time-stamped around 12:25 a.m., John O'Keefe's phone was already moving west.
West, meaning?
Away from the street towards the house itself.
Okay, so how does that challenge the prosecution?
Because the prosecution's timeline says the car accident, the impact, happened right then at 12:25 a.m., presumably out near the street. If his phone was already moving away from the street towards the house at that exact moment...
It doesn't fit the hit by the car on the road narrative at that specific time.
Exactly. It suggests maybe he was already out of the car or something else was happening.
That's a potentially big discrepancy in the timeline.
And Alessi wasn't done. He accused Whiffen of excluding that specific finding the westward movement at 12:25 a.m. from his main PowerPoint presentation shown to the jury.
Ooh. So, suggesting selective presentation of the data.
That seemed to be the implication, raising questions about whether the jury got the full picture from the initial presentation.
That's a classic cross-examination tactic.
Yeah.
Highlighting potential omissions or inconsistencies. Definitely something the defense would want jury thinking about.
So that was the morning. Intense data stuff. Then things got weird.
The afternoon session. Right before the RCA experts. Wasn't there that juror thing?
Yeah, just briefly. A juror had a private chat with the judge. We don't know what about.
But the reporting mentioned the defense attorneys, Little and Alessi, looked unusually eager.
Yeah, which is intriguing, right? What did they think was being said? But ultimately, the jurors stayed, so a little mystery, then back to business.
And that business was the RCA experts, Dr. Wolf and Dr. Rentschler, testifying without the jury present initially.
Right. This was a voir dire hearing. Basically, the judge needed to decide if their testimony was admissible and what they could talk about if it was.
Standard procedure for expert witnesses sometimes. So Dr. Wolf went first.
Yes. He was the main contact between RCA and the defense team, and the judge ordered all their communications had to be turned over.
Full transparency. Okay.
We learned some T-Mobile data got lost when they switched carriers, couldn't get it back, but Wolf said he'd provided everything else he had.
Data loss happens, unfortunately, as long as it's documented.
Then Prosecutor Brennan started his cross-examination, and he really zeroed in on how RCA got hired, how they were paid.
Trying to establish potential bias, presumably.
Seems like it. But the background here is really important. RCA wasn't initially hired by the defense.
Right. They were brought in by the Department of Justice for the federal investigation into this whole case.
And their report from that federal work was finished and shared with both sides, prosecution and defense, way back in February 2024.
Okay, so the defense saw this pre-existing DOJ report and thought, hey, this could be useful.
Exactly. But it was complicated because RCA was technically still under that government contract. Made things awkward for the defense, apparently.
I could see that. A government contractor testifying for the defense? Unusual.
Dr. Wolf explained he gave the defense standard contact info. Brennan's questioning got pretty aggressive, though, demanding yes-no answers.
Trying to pin him down.
Wolf clarified he got permission from the DOJ to testify. He explained RCA logs all their time under the original DOJ case number. Payment goes to the company, not him personally.
Standard practice for consulting firms.
But here's a twist. Wolf said he didn't actually know if RCA had sent invoices for this work or who got them.
That's a bit surprising, maybe. Or maybe just not his department.
Could be. But Brennan seized on it, asking this really pointed question. So when did you start advocating for the defense?
Oof. Direct accusation of bias. How did Wolf respond?
He was pretty firm. Said, I stand by the science and my analysis. That's the side I'm on. Repeated it when pushed too. I'm on the side of the analysis that I stand by.
Pushing back hard. Emphasizing objectivity. Allegiance to the data, not a side. Crucial for an expert.
Brennan then focused on calls made on April 24th, the day the DOJ apparently gave the okay for testimony, implied that's when Wolf reconnected with the defense.
Trying to build a timeline suggesting coordination.
Wolf admitted to a couple of calls, then talk turned to earlier chats with Alan Jackson, one of the defense lawyers, before the trial started. Wolf said those were mostly just logistics, scheduling.
Downplaying the content.
Said there was basically no contact for a year after that, except a thank you text he later deleted. Emails were submitted to the court, though.
Okay. documenting the communication trail.
But then this came out. Alan Jackson preferred using the Signal app for communication.
The encrypted messaging app. Why?
Because, according to Wolf's testimony, the prosecution had asked to examine the phones of not just Karen Reed, but also her parents and the defense team itself.
Wow. Okay, that explains the desire for secure communication. That's a pretty broad request from the prosecution.
Definitely raises eyebrows, gives you a sense of the tension, the level of scrutiny.
No kidding. So the defense reached out again more recently.
Yeah, in 2025 to formally ask ARCCA to testify at this trial. And they gave ARCCA the prosecution's own expert report to review.
Standard practice to see what the other side's expert is saying.
Judge Cannon jumped in at one point, asking if the ARCCA report itself could have been available earlier, before May 7th. Then the mood shifted.
How so?
Dr. Wolf started talking about harassment, really toxic stuff.
Harassment directed at him.
At him, his family, hate emails, people harassing his wife online, sharing pictures of his kids.
Oh, that's awful. That's crossing a serious line.
Yeah, he sounded emotional.
Yeah.
Said he'd been accused of perjury based on false information. People just accept it as true. It really highlights the human cost, the pressure these experts are under in big cases.
Absolutely. It's a stark reminder that these aren't just abstract legal battles. Real people are involved and can be deeply affected. And it raises questions about the whole environment surrounding the case.
And in the middle of describing all that, he made this really key statement. He said, basically, look, the RCA report everyone's talking about, it was done, finished, before either the defense or the prosecution ever even spoke to us.
So emphasizing the timeline again.
Yes. He stressed it was unbiased, documented with the DOJ before any contact from the lawyers in this trial.
That's a powerful point for the defense. It argues the findings are independent, not shaped by who hired them later for testimony.
You'd think. But Brennan kept going, focusing on this outline. Wolf sent the defense the night before testifying.
An outline of what?
Potential questions and answers. Wolf said he sent it himself, standard prep. But Brennan honed in on one line.
Which was?
Something like, it's important to show the jury that the physical examination of the vehicle is unnecessary in my analysis. Brennan jumped on that. You were trying to guide the jury, weren't you?
Accusing him of telling the lawyers how to influence the jury.
Wolf's explanation was calm. He said he just meant his analysis was data-based, so for his specific analysis, a physical car exam wasn't needed. Didn't mean it wasn't needed for other purposes.
A subtle distinction, but an important one in terms of methodology.
Brennan kept pushing, suggesting coordination. Wolf seemed genuinely confused by some of Brennan's questions at points.
Sounds like a tense cross-examination. What about the other RRCA expert?
Dr. Rentschler testified much more briefly, confirmed his time records, said he'd kept in touch with the DOJ, not the defense directly.
Okay, so reinforcing that link back to the original federal investigation.
And then right at the end, one more little bombshell.
After all that, what now?
It came out that Dr. Wolf, after he finished testifying for the day, had lunch near the courthouse while waiting for a ride the defense arranged.
Okay.
And during that lunch, he accidentally ran into Karen Reed and her parents and had a brief conversation.
Oh. After testifying.
Yes, after testifying. Might seem minor, but, any contact like that between a witness and a defendant, even accidental.
Yin raise appearances issues. The timing is key. Happening after testimony is different than before, but still something the court might note.
Exactly. So after that marathon day, what are the big takeaways? I see two main things.
Okay, what are they?
First, the prosecution started with this massive dump of complex mobile data, but the reporting suggests it didn't really land, like it might have been too much, too technical, lost people's engagement.
That's a real challenge, making complex data understandable and compelling to a jury. It's easy to get lost in the weeds.
And the second thing, maybe the most crucial point from the RCA testimony, that their report, their analysis, was done and dusted, submitted to the DOJ before the defense or prosecution in this trial ever contacted them.
Yeah, that timeline seems fundamental. Whatever drama happened in the courtroom later, that fact, if true and documented, speaks volumes about the report's potential independence.
It feels like a bedrock fact they established. Then there was the judge's tone.
Getting stricter.
Noticeably so, yeah. Mentioned potential discovery violations, said the defense might not have submitted everything they were supposed to on time.
Procedural battles. That means one side thinks the other didn't share required information properly.
And the judge warned she expects arguments on this, and they might be intense and snarky. So, sounds like tensions are definitely rising on the procedural front, too.
Not surprising in a complex case. These discovery disputes can really matter. affecting what evidence comes in.
So yeah, recap. Google search timelines debated, phone data suggesting O'Keefe maybe wasn't inside the house when the stair data logged, that westward phone movement challenging the accident timeline.
Then the whole ARCCA expert saga, the DOJ connection, the harassment claims, the pre-existing report, the intense cross-examination.
Plus the juror mystery and the looming discovery fight. It was a lot. Long, exhausting, definitely dramatic.
Packed with details that could really sway how the jury sees things.
So here's something to think about for you listening. When a trial hinges so much on super technical expert stuff like this, how does a jury actually process it all?
Yeah, can lay people really grasp all the nuances of, say, cell tower data analysis or phone temperature logs?
And how much do things like an expert seeming objective or maybe seeming biased or even small details from cross-examination end up influencing their final decision?
What does Day 5 tell us about the real-world messiness of presenting forensic evidence in court? It's not like TV, is it?
Not at all. Lots to chew on there. We'll be back soon to dive into the reporting from Day 6.
Looking forward to it. Until then.